Sam Saad and I are here this morning from the NABOR Legal Resources Committee. I'm currently serving as chair, and Sam is my more than valuable vice chair. We're here this morning to address the issues that may be contract related that you might have had with any pending contracts or future contracts that as they relate to the impact of Hurricane Ian. And we are here to answer your questions. Unfortunately, we probably don't have time to do individual case studies or war stories, as I call them, but we'll try to go through the differences between the two contracts as they relate to risk of loss and force majeure. We'll try to point out some key points to you to consider in dealing with your customers after the storm. And then we would be happy to take your questions. Please don't put them in the chat. It's a little too hard for us to monitor the chat, but we will monitor the Q&A and we'll take those questions as they come along. So thank you for that. With that, I'm going to turn it over to Sam. Sam, do you have some words to start with?
I just want to say thank you to everybody for coming on the call today. I know that we're all a little crazy and hectic, and like, for example, we still don't have internet at my office, so we are working remotely. You can see I'm actually at NABOR because they have internet and air conditioning. And so just feel free to answer your questions. Jeff, do you want to go? Are we going to go through the contract a little bit, or are we just going to take questions?
Well, I think what I'd like to do is to start out with a few points that we made in our video on that we sent out last Friday, and just talk about some key points. And then I think, yeah, Sam, let's go through the NABOR contract and the FAR/BAR contract as the key points of risk of loss. Now, first of all, I have a few points here that we used for our video last week. You know, both contracts provide for inspections that can be done after the storm has passed to investigate and discover any damage that's occurred as a result of the storm. NABOR specifically calls for a post-loss inspection. FAR/BAR, we think that there is a provision in the contract where the seller is able to allow the buyer to come in and do an inspection, especially walk through, but we think, and Florida Realtors thinks that you can ask for one before that. So the second point that I have is, please do not even think about serving as the inspector for your customer. That includes going by and taking pictures. That includes any representation to your seller about any possible damage that might have occurred or lack of damage because you aren't able to see it. Always, always, always bring a qualified inspector with you. Have them be able to use their professional skill, whether it be a contractor or an engineer, to use their training and skill to make a determination for your customer as to what the issues are and how they can go about solving them. That's really important. And I think, as Sam and I said maybe 50 times in the video, be the source of the source.
Right.
Please offer the possibility of your customer to talk to a wealth advisor to understand their limitations, an insurance expert, an engineer, a contractor. They're all available. There's some very good ones in Naples. And also, let's not forget your real estate attorney. One of the key assets that you have in interpreting the contract and determining your best steps for moving forward. So be the source of the source. Be free to recommend to your customers people that they can talk to that are experts in their field. Please do not opine or give your thoughts, because those could be very damaging to your relationship with your customer. Sam, feel free to add to that if you like.
Well, I was going to say, you know, we say all the time, be the source of the source, and you just got to work your networks. The most important thing that you can do is give peace of mind that you are working to help them, that their property, you know, will get resolved through the insurance process. Get them in touch with their insurance agent, and just be very careful about what advice you give, I guess the best way to say it.
The other point that I had is always remember the type of complex that you're dealing with. Is this a single family home in Naples Park or Connors? Is this a condominium community? Is this an HOA community? All of these have direct effect upon your customer's responsibility for damages and repairs. And we'll talk in much further detail about that, but a condominium has certain requirements and coverages, and your unit owner has their limitations of what they need to cover and what kind of damage assessments that they're facing. And Sam, you want to add to that? I think the type of community is really important in thinking about what you're going to be working with in your customer.
Yeah, I mean, if you've got I think about it from the contract perspective. So your contract, whether it is FARBAR or NABOR, says that you are responsible for dealing with the unit itself. The contracts define property as the interior condominium unit or the single family home in the HOA, but it specifically excludes association property. So one of the biggest things I'm seeing is condos that were destroyed on the beach, for example, or even inland, where the roof was badly damaged. That's typically a common element, and it's association property. So you've got to kind of know. It's easier in condos, I think, to Jeff's point about knowing your community. It's easier in condos to know that you deal with the drywall in for your unit, but in HOAs where the landscaping was wrecked, the gate was wrecked, and the place looks beat up from the storm, your sellers are not responsible to fix association property. They're not obligated to repair the roof of the condominium building as part of the closing process. They're not obligated to fix the landscaping in the HOA. So when I'm seeing a lot of buyers saying, diminution in value, and the contract covers that, they got to close if the roof leaks for the association. There's going to be a special assessment. Remember, NABOR says everything that's assessed from the effective date forward is the buyer's responsibility. FARBAR says everything that's assessed from the closing date forward is the buyer's responsibility. So just to Jeff's point, you've got to pay attention to what your documents say in the association.
Last Friday, we released a Hurricane Ian disclosure that parallels the Hurricane Irma disclosure that we had for many years. It is a document. It's available in the NABOR library. It'll be available in your vendor's library here in the next couple of days. But it is a Hurricane Ian disclosure, and it is there for you to use, alerting your customers to the possibility of assessments and the possibility of costs that need to be considered when you're going to contract. And of course, in contract, we'll talk a lot about what the risk of loss provisions most contracts talk about, which I guess brings me to my last point is you have to know what type of contract you're under if you're dealing with a pending contract. Are you in a FARBAR contract? Doesn't really make any difference, Sam, whether it's as is or regular. The risk of loss provisions in both contracts are identical. So it doesn't really matter that it's as is or that it's a regular contract from the standpoint of the storm damage and risk of loss. Would you agree with that?
Yeah, so your FARBAR regular and your FARBAR as is have the same risk of loss provisions. Your NABOR as is and your NABOR regular contract have the same risk of loss provisions for the most part. So you do have to know your form. Jeff, you want to go through? Hold on, we have two in the Q&A.
We can do the Q&A. The first one is easy. It's the video was sent out in an email blast to all NABOR members. I believe it was. We did it on Thursday morning. I think he distributed it either that same day or first thing Friday morning. There's also a NABOR video library that you can access by logging into your with your password into the NABOR video library. If Michelle, if you're listening, if you could post that link to the NABOR video library. I know you get it there. So then we delve into a contract from Nancy. If someone wants to get out of a regular NABOR contract because they got an insurance quote they feel is unreasonable, how is unreasonable defined? How would one prove that? Is that a valid reason to terminate a contract? There are very few insurers now in Florida, which may contribute to the high cost of insurance. Okay, so we've had several forums, and I know that in contract classes, we're letting you know that that's a disclosure that's in the contract, that the buyer has agreed that they've looked into insurance costs. Obviously, if you're in an as-is contract and you're in your due diligence period, you have the right to check insurance and determine if that is a something that's going to be agreeable to your customer. And if they're doing financing, are they going to be able to afford it? It may affect the loan to value calculations or the income to debt ratios. So it's very important that you check that out. I know another point we're trying to make in this discussion is your buyer can assume the seller's flood policy. This could result in a good savings because flood policies are gradually inching up to where they're eventually going to become actuarial, but they've been A, all over the place, and B, inequitable until this new, what we call FEMA 2.0 that started in April. So if you get a quote for your flood insurance and it's well above what the seller's paying now, at least the buyer could assume that policy and get the lower rates throughout the life of the term of that policy. Right. So, Sam?
So the question is how about the reasonableness of the policy as well. Nancy, the short answer is whether it's reasonable or not depends on what 12 members of the jury and the judge think is reasonable. When you get into trying to prove reasonable versus unreasonable, it becomes very difficult and it's very fact intensive. You have to compare history, likelihood of binding it in the future, and come up with reasonableness. And I hate to be so vague, but the contract is vague on this point because the law is vague as to what reasonableness is. You know, when I was in law school, we used to joke, "What is the reasonable man?" And no law professor could answer that question. So I doubt there can be answers now, other than to put it in front of a jury and say, you know, it was $5,000 a year before the hurricane. Now it's $10,000 a year, and I can't afford it. Therefore, I think it's unreasonable. And I think the other message, Jeff, that we tried to get across in the video really relates to this question that Nancy's asking is, we've got to all work together and come up with some way to cooperate and get along and get these contracts closed. If it's absolutely impossible, the buyer just can't afford the new insurance especially if it's a situation where they're getting a loan and the ratios are all going to be off, then you just have to work it out with the seller. And that may mean negotiating the deposit, a portion of the deposit going to the seller for their inconvenience. The last thing we want to see is a bunch of deposit claims going through the court system, because it's just going to make a mess of things. There's a phrase in the law, especially in real estate, because we deal in courts of equity in real estate, and we say equity does what ought to be done. I just have a hard time thinking that a judge and jury that just went through a hurricane, you know, it'll have been a year, it'll be next year before you even get to court, saying, well, the seller gets $50,000 because the buyer couldn't get insurance, even though the price of insurance doubled. I just have a hard time seeing that case getting made. So sellers are going to have to be reasonable.
I think a best practice for us all, and we've been trying to emphasize this as the insurance picture in Florida continues to deteriorate, is always check the insurance out. I mean, we're not in an environment where we're getting 31 offers on every property and you have to make your offer quickly. Take your time. You can now call an insurance agent and get a homeowner's quote and a flood quote without having to wait. So always make that call early on in the process. maybe you make that call when you have a buyer that's interested in a particular neighborhood. Make that call early. Don't let your buyer be surprised by the cost of insurance.
Well, hold on. Now, maybe I didn't understand the question exactly, because what I'm answering is questions that are in contract now. If you've got a contract if you got a deal going to contract, the contract says the buyer is under the obligation to investigate the insurance prior to contracting. So you're not going to get out of it if you just go into contract and find out, oh my God, I can't afford the insurance. It's only if the insurance changed as a result of the storm is how I would interpret it, the NABOR risk of loss provision.
Yeah, I think
for reference, for those of you that are looking in the contract, it's standard D2E, approximately line 343.
Yeah, so in contract is one question. Prior to submitting and going under contract is another. And the contract essentially says that you know the insurance costs before the contract was consummated. FARB has a rider that says if the insurance exceeds a certain amount, that the buyer can get out. So whether or not we would add that to the NABOR contract, there's not one at this time. All right.
So we got to deal with the contracts as they come. So yeah. So right now that there is nothing in NABOR.
Says I have a buyer from out of town and went under contract a week before Ian. She's made both deposits. Inspection completed. Financing contingency in effect till 10/1. The lender is sending out a FEMA inspector to look at the property as well, although the property is not located anywhere that received damage. She is now not wanting to move to Florida. And she wants to know if she can get out of the contract. Sam, you want to take that one?
Yeah, so this buyer is probably not going to get out of the contract. It doesn't say whether it's an as-is. If it's an as-is and you're still in the due diligence period, you can terminate for any reason or no reason. If the finance contingency is up under NABOR, and you've not been approved, you can get out of the contract as long as you show good faith and diligence in the application process. This is unclear. I'm just rereading this.
Well, the lenders in all cases.
If the lender wants to go out and do another inspection, so they haven't given the final approval yet. Under NABOR, you could get out of it. Under FARBAR, you could not, because the 10/1 deadline. If
the lender declines the mortgage as a result of their inspection, right? Then they would.
Although FARBAR does, Jeff, FARBAR's got that provision in the in the financing section. And I can't pull up the FARBAR contract right now because my computer's acting up on me to read the exact language. But if it's got a property-related condition after loan approval has been obtained and the loan doesn't go through as a result of a property-related condition, I think in FARBAR you could still get out of it.
I think you're right. In NABOR, if the lender sends an appraiser out and the appraiser says there's damage, and then I believe the lender could deny the loan. Right.
Lender could deny the loan, but remember in NABOR, she didn't say that it was waived, but if the finance contingency is waived in NABOR, then the seller's got to fix the damage, but the buyer can't get out of it.
If she says the financing contingency goes to 10/18, so theoretically she's not waived yet, and therefore,
18?
If the lender came back,
there it is. I see it. Okay.
The lender came back and said we can't make the loan. She has the right then to get out under the financing contingency.
Right. You're right.
Okay, we got you. Kim, we had a insurance class this summer where we had insurance carriers involved, and we could certainly redo that class, but we were trying to alert people as to the current insurance situation, and we had Trey Goldman on there from Florida Realtors. We could certainly redo that. I'm chair of the Florida Realtors Insurance Committee this year, so certainly we could refresh that class. It's a good idea. Well, maybe if Michelle's listening, we'll pass that on to her. Thanks.
Okay, thanks, Aaron. Aaron posted the FARBAR excerpt related to property-related conditions.
Farbar X. Did you get that one already? Okay.
Sorry, that was Aaron posting. Aaron just posted the Farbar language. It's fine.
Okay, so we have a little lull in the questions. Sam, let's start with the NABOR contract and talk about the risk of loss paragraph and what key provisions are in there.
All right. So I'm talking about contracts that are pending now. I'm not talking about contracts you're going to get into. So this is NABOR's risk of loss provision. It's standard D2E sub 1. Any loss or damage to the property, including landscaping, systems and equipment, or personal property caused by fire, flood, extreme weather conditions, or other casualty occurring between the effective date and the closing date, whichever is earlier, shall be at seller's sole risk and expense, and seller has to maintain their insurance until disbursement. So what does that mean? It means it's the seller's problem until closing or possession if there's damage. So if you had a property that was damaged, the seller's got to repair it, and they got to escrow 200% of the estimated repair cost, even if it's a casualty loss, unless the buyer wants to terminate. And when can the buyer terminate? When as a result of the casualty, the buyer is unable to obtain insurance at a reasonable rate, or if services essential for closing are not available for a period for 30 days after the casualty date. So now I'll just break that up a little bit. As far as services essential for closing, pretty much everything is available. The one thing I've been seeing people argue and possibly getting some traction on, well, we don't have power, so we can't determine what was actually damaged in the hurricane because we can't turn the appliances on. So we don't know. That means services essential for closing are not available because we can't get it inspected again. And that could be a plausible argument. If that continues for 30 days, then maybe the buyer can terminate. Again, I'm preaching reasonableness amongst the buyers and the sellers, and we want to keep these deals together. But if buyers are absolutely adamant they want to get out, there's an opportunity there. If the property is unfit, is uninsurable under the citizen guidelines, or the property is uninhabitable as determined by the county or the city, then the buyer can terminate. They have 5 days after receipt of notice that the property is uninhabitable or uninsurable. The next paragraph says that any loss if any loss or damage to the landscaping caused by the casualty or other event beyond the seller's control, where is it? The seller's financial obligations are limited to 1% of the purchase price. So no matter what happens, if the landscaping is destroyed, but the property is otherwise inhabitable, the seller only has to fix up to 1% of the purchase price. So that means that, on your $500,000 home, seller's got to come out of pocket up to $5,000 to fix landscaping. That's not going to replace a royal palm tree that got knocked down. And the contract covers that as well, saying that the seller's obligation for the 1% is only to the extent reasonably practical based on the availability of substantially equivalent replacement landscaping. So you're not going to be replacing royal palms. They're just not available. The giant fan palms, a lot of this stuff got really ruined by the storm. It's not going to be replaceable. And so you're going to have to negotiate a credit or work through what the seller is going to do up to 1% of the purchase price. Okay. Now, the one thing, the buyer does get a post-casualty inspection under the NABOR contract, not later than 5 days after the buyer has been notified that the property is safe to be accessed. Then the buyer can come in and see what damage was done, and the seller's got to provide reasonable access to the extent possible for utilities on the property. Now, the last provision of NABOR says that if due to a pending or threatened hurricane, insurance is unavailable, then you can delay. Well, we're past that. So that last paragraph, I'm hearing a lot of people say, well, I want my extra time to close under this last paragraph. This last paragraph doesn't apply anymore because the hurricane is passed. So I'm talking about, I'm looking at standard D2E sub 6. Okay. Before I move on to FARBAR, and I know it's a little disjointed because I'm trying to read this as I go through on a very small screen. Does anybody have questions on what the NABOR provisions say? Anonymous says,
NABOR has his contract with confirmed roof damage. The buyer has asked for a credit in lieu of roof repairs. Assuming the lender would be okay with this, would you advise for or against this, and could this potentially lead to after closing issues? Sellers are on board with escrowing funds at closing for roof repairs once we have had confirmed the total cost of the damage.
So I am a big fan of credits as opposed to escrows, because that way the seller is out of it. You're not dealing with a bunch of parties trying to figure it out. The buyer and seller say, okay, credit, seller goes away, buyer moves forward, and it's on the buyer to negotiate a credit. So get a good roofer in there that understands the situation and is not, a fly-by-night roofer, and get a good estimate, and then give a credit and have the buyer take care of the problem. I like this because that gives the buyer control over the repair process in a way that's going to make them happy, and it's also been my experience that buyers get in there and they start, thank you, Jeff. Buyers get in there and they start seeing other things they want to do. So that, for example, the contractor comes in, well, maybe they want to change the way in the case of a roofer, they want to change the way the ceiling looks and do vaulted ceilings, for example. I've seen that case. Or if it's a general contractor coming in to do other repairs, maybe they start changing their mind and they want to move walls around. So that just gives the buyer flexibility. That's my considered opinion. I'm not sure.
It gives the buyer control over the
buyer control issue, exactly.
Sellers essentially motivated to do it as quickly and I won't say cheaply, but most reasonably priced. Buyer, as Sam said, the buyer can accept a reasonable credit, and if they want to augment that or they want to do it differently, that's the buyer's option after closing. I'm guessing that how would a lender deal with that? I'm guessing a lender would deal with
that's a different scenario. When you've got a lender involved, lenders want to loan to properties that are put together correctly and not have problems, and they don't like credits to buyers at closing except for closing costs. So depending on the size of your problem, usually your closing costs can't exceed 3% under the lender guidelines. So you got to figure out what your 3% is, and then get a credit as much as possible. If you've got to do an escrow, it's going to have to be off the closing statement, or you're going to have to wait and do the closing after the repairs are complete. Those are pretty much your only options.
Okay, Sam, I was able to bring the risk of loss section up.
I'm looking at it. Yep.
Is there anything else in there that you'd like to comment on as far as what we see in there?
So this standard right in the middle of your page, if you got the screen up, standard D2C sub 2, availability of insurance is essential for closing. That's the provision that we're dealing with. So if you're unable to get insurance or unable to obtain insurance at a reasonable rate, then you can terminate after 30 days of not being able to do so. So that's really the provision that we're dealing with in terms of buyers trying to get out of the contract right now. I think that's the most important point at this juncture where we are post-storm.
From a risk of loss standpoint, the question that was asked earlier, what happens is if the we got into the area of reasonableness again, but if this was after a risk of loss and the buyer was unable to obtain insurance or insurance at a reasonable rate, then there is the provision in there that the buyer can delay the closing, or if it goes continuously more than 30 days, either seller or buyer can terminate. So does that give you a little bit of an angle, Sam, if it's after the storm and the insurance quote comes in at a very high rate? Or not available?
The buyer, if it's unreasonable, and I don't know what reasonable versus unreasonable is, if it's unreasonable, the buyer can get out. And Aaron, you're asking if there's no damage as a result of the hurricane, but it's not available at a reasonable rate. I would say, yeah, the buyer has an out. Is that Aaron Miller Myers asking that? Yes, I would say that, Aaron, in response to your question, I would say that if you can't get insurance at a reasonable rate for 30 days, you could get out of it. That's what the contract says. But again, it's what is reasonable. And is it reasonable given the circumstances? Is it reasonable given the circumstances before the storm? And insurance is so screwed up in Florida already, and it's so expensive already for everybody, that what is reasonable in New York or New Hampshire or Chicago or wherever is not going to be what's reasonable. I think you got to look at what's reasonable given Florida's really bad insurance market. So
I'd like to make reference to Subsection 3. We are learning of buildings that may have incurred substantial structural damage,
right,
as a result of the extensive flooding from the storm surge. So remember that it could be that damage created an uninsurable situation or an unfit for habitation. Now, I know there are properties off of Gulf Shore Boulevard, I won't mention any neighborhoods, but they've been condemned because of mold damage to the lobby and lower floors. So those are situations that are very real as a result of Ian that we didn't see as a result of Irma. So there's a section there that probably wasn't a big deal after Irma, but may be a big deal for you and your customer after Ian. Right?
And the other issue about that, Jeff, you got to be careful. Like I said at the very beginning, read the section. If any such casualty or loss or damage renders the property uninsurable or uninhabitable, you get out. If the condo lobby is uninhabitable, but the unit itself is on the 17th floor and it's just fine, can you get out of it? It's not part of the property, and the contract specifically excludes association and common areas from the definition of property. If you have a recalcitrant cellar, I think you've got a problem and you're going to have to close, even though you can't get into the unit because the lobby is too damaged. I think the way the way you read this, it's going to be tough. Now, would a judge or jury ever do that? I don't know. But if the unit is fine, but the lobby is screwed up at the building, I think under NABOR, you got to close.
Okay. That's a great point.
The same thing if you're a homeowner association and the landscaping is trashed and the property doesn't look as beautiful. Like for an example, my parents live in Gray Oaks, and Gray Oaks got hammered. But it's the unit, the property is the single family home. And the association property, there may be an assessment to put all that back together. And if you're already in contract, that'll be the buyer's issue. If you're not in contract and the assessment gets properly assessed, it's a seller issue. But I don't think that it fits into the definition of property.
Okay. And then how about talk a little bit about paragraph 6. This is where we define what an extreme weather condition is. There's no force majeure in the NABOR contract, but this is the attempt for the contract to define what an extreme weather condition is.
Can you scroll up to paragraph 1, sub 1? I think that's where we define casualty.
Right there?
Right there. We define casualty as any loss or damage to the property, including landscaping, which is caused by flood, fire, extreme weather, or other casualty. occurring between the effective date and the closing date. That's casualty. That's the only definition that we have in the contract for extreme weather. I think paragraph 6, as you're pointing out, so if I can look at paragraph 6, it talks about extreme weather, but it references.
That's mainly insurability, correct?
Yeah.
Okay. All right, we have one other. Would it be an uninhabitable if the building is deemed condemned?
I would say yes. If the building gets, and I have this problem again, it's all public record. I don't mind saying my parents live in the Billows, which is on Gulf Shore Boulevard. They don't live there. They have a condo there. And the question is whether their building is going to be condemned. So if that's the case, then it's uninhabitable.
All right, so let's switch over to FARBAR. I believe I can bring that one up.
Yeah, I can't get into my FARBAR contract, Jeff, so if you can pull that
up. I got it right here. This is the as-is version, okay? I think you want to maybe talk a little bit about the various sections of this contract.
Yeah, go to force majeure first, if you get it up.
Right here?
I can't see it. I don't think you're sharing your screen.
Oh, okay. Well, let me try to do that. Is that better?
Bingo. Scroll down to force majeure.
You want the closing right there?
Yeah, right there. Stop. Okay, so 5B is an extension of the closing date for force majeure in standard G. So let's go down to standard G. Jeff, let's go to standard G. Why is this so small?
I'm getting there.
Take your time. I'm just trying to figure out. There it is.
There it is. Okay.
All right. So the buyer or seller shall not be required to exercise or perform any right or obligation under this contract so long as performance or non-performance or the availability of services or insurance or required approvals essential to closing is disrupted or delayed or caused by or prevented by a force majeure event. So before we even define force majeure, go back up, Jeff. Let's just talk about what that sentence means. If you can't perform because of the force majeure event, which we're just going to say, where it says trade out hurricane for now, if you can't perform, you can't get service or you can't get approvals because of the hurricane, you can delay the contract performance under this contract. Jeff, can you scroll down a little bit now? How long can you delay? You can delay for up to 7 days after the force majeure event no longer prevents performance, not more than 30 days. So we are, that was, see, it was September 28th, so we're at day 12. So if you still can't get, this is FARBAR, of course, you can't get insurance, you can't get dissociation approval, you can't get in there to inspect the unit because the elevator's busted because it was in the flood, then you've got up to 30 days to get the essential services, the insurance or the approvals back. And then then you have 7 days to close once that happens. And it's going to be a case-by-case basis. So but it goes somewhere in here. Yeah, it's 30 days past the closing date. So if you had a closing set for the 30th, then we could go out to October 30th. Can you scroll up, Jeff, real fast? I want to see something. Up a little bit. Just right there.
Still up?
Nope, you're good. Scroll down. I thought it said in here it was from when this force majeure event passes. Okay, it's 7 days after the force majeure event no longer prevents performance. So it could be after the 28th. So,
but it could be
not more than 30 days past the closing date.
Closing date. So that actually 30 days past the closing date,
Yeah.
we're already 12 days. If you had a closing on September 30th, we're already 12 days past the closing date now. So
Right. Well, 10 days past the 30th, right?
Right.
So the FAR bar is a little more forgiving, in my opinion, but under force majeure. But again, our goal is to keep deals together. Go down, and this is where I think our risk of loss is better, right here, section M.
So, but let's just stop real quick at section L, because there's no provision in this contract for a post storm inspection. However, in reading some of the FAR bar results here, they're basically saying standard L does obligate the seller to allow on reasonable notice utility service and access to the property for appraisals and inspections, including a walkthrough or follow-up walkthrough. So,
and I agree with that. That you have to, under FAR bar particularly, but NABOR also has the post casualty walkthrough, or the post casualty inspection. The FAR bar contract says buyer gets access to the property pretty much throughout the entire pendency of the contract. I think that's the safest way to interpret that. Risk of loss. So if after the effective date but before closing there's a casualty loss and the cost of restoration does not exceed 1.5% of the purchase price, the seller's got to repair. If the seller can't repair, then you escrow 125% of the cost, not to exceed 1.5% of the purchase price. Under FAR bar, the seller's maximum out of pocket for a casualty loss is 1.5% of the purchase price in all cases. If the seller wants to go over 1.5%, they can negotiate that with the buyer. If it is over 1.5%, the buyer has the election to take 1.5% as a credit and then take the property as is, or the buyer can terminate. And that's the buyer gets to pick that.
So there's another point in here.
Yeah.
1.5% is a relatively low ceiling for the kind of damages we saw in Ian, but
Yeah.
the interesting thing is the way this contract deals with landscaping.
Well, that's the other thing. In the NABOR contract, it's 1%. In FAR bar, the seller just has to prune and remove debris. So prune the trees, get them back to looking as good as they're going to look, and remove all the debris. So, and again, they don't have to spend more than 1.5% of the purchase price. So if you look at that up there on line 512, it says including the cost of pruning and removing damaged trees.
Okay, we got a couple questions. Once you finish the sales side, can you highlight review rights of tenants that rented and the property is affected by flood, both condo and co-op on Gulf Shore and single family?
Yeah, Deborah, I can answer this very easily. Look at the lease. I've got leases that say the tenant's responsible for everything,
Yep.
and the tenant is screwed. I got leases that say the landlord is responsible for everything, and the landlord is screwed. So you got to look at the lease under all it. There are basic standards in the statute, but the statute can be overridden by the lease. So in residential and commercial, you got to read your lease. I can't answer a specific question as regards to tenants' rights generally. It's whatever the lease says. Okay, anonymous. Do we still need to write up a closing extension?
What are the rights to end the lease based on damages? So that's all covered in the lease, and that's where the only place you can really look.
Right. If your lease is silent, sorry, Joe. If your lease is silent, there are statutory defaults for residential. The property's got to be maintained under Chapter 83. I don't have that section memorized. It's the heater has the heat. Ironically, there's no provision for a working air conditioner in Florida, but the heater has to work. The property's got to be up to code, and something else. I think it's a 3 or 4 part test. but I would say read the lease. And then the next question we have is, do we still need to write up a closing date extension if the force majeure provision already extends it for up to 7 days? No, you don't.
The extension's automatic, correct?
Yeah, it's not an extension in quotes. It's a force majeure, but it does extend the closing deadline. Okay.
Okay, done and done. Good. All right. Is there anything else in FAR bar that we need to talk about with regard to storm damage?
I
don't think so.
No, I think we covered it all. Those are the big ones. Other questions people have? Put them in the Q&A. I don't think the chat's working.
There's one. Here's one. Can you contrast the seller's maintenance obligation under NABOR? Would the seller ever have to come out of pocket in order to close? For example, the seller has a mortgage and there is significant damage to the landscaping and screen enclosure.
Aaron, seller's maintenance obligation under NABOR. Seller's got to bring the property back up to spec. If I go to D2E1, anything that happened prior to closing is at seller's sole risk and expense. They get out of landscape damage at 1%, but the seller's got to return the property. It's 200% escrow under NABOR. FAR bar is 125% up to 1.5% of the purchase price. But I hate to use the word unlimited. But in the NABOR regular contract, the seller's got unlimited liability. Hopefully they've got insurance. Anonymous is asking, NABOR as is, what is the risk of loss percentage for seller's responsibility? Yeah, Anonymous, the NABOR risk of loss under an as is, hold on, this you're asking as is, the seller takes as is, but they've got to maintain the property as is, where is, as of the effective date. So whatever it looked like on the date the contract was signed, it's got to be basically back to that wear and tear accepted.
And there is no percentage.
And there's no percentage. So it could be a lot of money to the seller.
Okay.
Oh, yeah, another one. Under FAR bar, if the first deposit was due 9/29, the buyer never made the first or second, but the contract's been executed, can they walk away? The buyer's ghosting the agent. I suggest contact attorney. Any other advice? So this is a great question under FAR bar. If you defaulted on your first deposit, your second deposit is due and you're in breach, you owe both deposits, but 9/29 was the day after the storm you would get until you could make your wire. So here's the question I would ask, where's your buyer? Are they up north and they just don't want to deal with it, but they could have made their wire on the 29th because the banks can receive the money. You know, if you're at Wells Fargo and the title company is at Bank of America, wires can go through. I don't know that the force majeure provision prevents performance of that obligation. So I would say this ghosting buyer is probably in breach because it's now the 10th of October. They're probably in breach, and both deposit amounts, whatever that is, goes to the seller in your situation.
So there was an article that was written by the Florida Realtors attorneys dealing with situations where you go under contract and no deposit is made. What are the rights of the seller? And we've had a lot of cases where people went under contract and never made their deposit. In NABOR, the seller's remedy is deposits made to date. But in FAR bar, I think their argument is that could be a default and the seller could try to recover. What do you think?
That's exactly right. If you sign a FAR bar contract and then you ghost the seller or the realtor, you're liable. And let me point something else out. On those contracts, both FAR bar and NABOR, there's an address line for legal notices. I can't tell you how infuriating it is as an attorney when the realtor does not put the notice address for the parties on the contract and then calls me and says, I got a problem. My buyer won't respond and I have no place to send him I don't have an email address. I don't have a letter address. I don't have a phone number. And the buyer's just disappeared. I mean, you leave me with nothing. So it's very important to fill in those. That's a pet peeve of mine. You got to fill in the notice address.
So, Sam, one of the things that I think we're caught up in the chat so far in the Q&A.
Yeah.
Everybody for hanging in there with us, and hope we got through quite a bit of material, and we're about ready to wrap up here. But one of the things that we said that was consistent throughout our discussion, our video, is try to keep the deal together. Buyers want to buy, sellers want to sell, regardless of the provisions in these contracts. Closing dates can be extended, damages can be worked out. If it's a situation where we can keep the deal together, what we found in Irma, the damage was a little different, mainly landscaping, not too much structural. But what we found in Irma was deals stayed together.
Right.
Buyers wanted to buy, sellers wanted to sell. So rather than pointing to specific lines in the contract and all that, what is the underlying desire of your buyers and sellers? And if there's a reasonable way to work it out, and the damage is 2% instead of 1.5%, try to keep the deal together. I guess we're going to have situations where now the lobbies have been wiped out, no elevators. Those are going to be difficult situations to deal with. But, they just restored the Pine Island Bridge in 3 days. They're supposed to have access to Sanibel by the end of the month. So some of these things that seem insurmountable today may not be. And we don't know what's going to happen to prices. We don't know what's going to happen as supply gets constricted again. So I think the thing we talked about the most was, if you can keep the deal together, get the help from your real estate attorney, get the help from the experts and the contractors, and try to keep the facts together, and try to keep the deals together as best as you can. I think that was our overriding message. Sam?
I couldn't have said it better. I mean, these people wanted to buy. It's not like it's a surprise the hurricanes happen in Florida. I think it's a matter of salesmanship on the part of y'all, just to keep the deal together, and I will help wherever I can.
So we're going to probably wrap up. I don't see any other questions here, but I think, try to keep the deals together as best you can. Seek out your local real estate attorney. If you're an agent, seek out your broker. We'll try to give you some help and maybe make a phone call or two to help you keep your deal together. But the other overriding question is, be the source of the source. Please don't offer your opinion or your thoughts on damage or what's going to happen or when the association is going to be able to repair the problem. Those are all areas that you need to refer to your local attorney, your contractor, the association management, because if you don't do that, you could put yourself in a position where a buyer or seller relies on something that you said to make a decision, and I don't think that's where you want to be.
No, that's when you let your insurance carrier, your own insurance carrier, your carrier, and your broker that you made a mistake, because that's a big one.
That's a Maalox moment for us brokers, Sam.
That's a Maalox moment for the broker. That's right.
So, okay, well, I don't see any more questions on the chat. It's 11:56. Thank you so much, Sam. You've been an invaluable resource throughout the year on legal resources, and especially since this storm has come. You've done some of your own seminars with your customers and agents, and you've been wonderful to work with, and I want to say thanks.
Thanks, Jeff. It's right back at you. You've been a great leader through this whole process. You drew the short straw, having taken legal resources through a hurricane, but you've done an excellent job of it. I'm glad that we got to work together, and we'll keep on trucking away. Listen, anybody, or I have basically suspended fees for now. It's a little frustrating, of course, for me, but I'd rather you all get your stuff done. Just text me if you have questions. As a matter of fact, I'm getting texted as I speak. Just text me or call me with questions. We'll all get through this together. That's all we can do.